I'm Aaron Romens. I am the supervisor for the Bureau of Consumer Protection for the state of Wisconsin. I work in the Wisconsin Department of Agriculture, Trade, and Consumer Protection, commonly known as DATCP. And I am here to talk about sort of landlord-tenant law as it looks like from a consumer protection standpoint. So a little bit about me and a little bit about what our unit does. As the supervisor of the mediation unit, I am not a regular presenter, and you will notice that in many different ways. However, what you should all know is that what I do in my job and what our mediation unit does in our job allows us to really understand what's happening in the world of landlord-tenant law and landlord-tenant relations in the state of Wisconsin. My unit of 12 individuals reads every single consumer protection complaint that comes to the state of Wisconsin, over 10,000 a year. And this includes a very large amount of landlord-tenant complaints. And so because of that, we are really able to see and understand what's happening. And so I really want to present it from that angle of, yes, we've seen it all. However, I will never say that when it comes to landlord-tenant law that I have seen it all or anybody has seen it all, because there's always more. There's always something new. There's always something different happening. And for many of you in your positions, I'm sure that you are also experiencing that as well. So with that, allow me to jump into the presentation here a little bit. I'm going to start with a little bit broad, and then we'll kind of hone in a bit on landlord-tenant law as we go. So with that, I work in the Bureau of Consumer Protection. Here's our mission statement. It's to ensure fair business practices for buyers and sellers alike by prohibiting fraud, deception, and unfair business practices in the marketplace. What I want to really talk about in the framework where we're talking about consumer or we're talking about landlord-tenant law is to think about the consumer protection angle of where we're from. I'm going to talk about laws that we do enforce. I'm going to talk about laws that we don't enforce. And when I'm talking about what we do enforce and why and how, think about it in this idea that tenants are consumers and landlords are businesses, and we work to resolve issues between businesses and consumers. And we also work to make sure that the business practices are fair, which is to say that one business is not getting an unfair advantage, maybe by bending or breaking the rules compared to another one. If you look then a little bit about what we do, we administer more than 70 consumer protection statutes and rules. When I say more, it's like actually way more than 70. It's so many. And they serve as a framework that allows legitimate businesses to flourish and provides consumers with confidence in the marketplace. Basically, if you break that down a little bit, what we're really trying to do is make sure that businesses are competing fairly and are getting essentially what they need to out of our economy, as well as the consumers, or in our case, the tenants, that the tenants are they're living in a situation where they feel that what they're getting in a rental agreement, what they're getting from their landlord is what they're expecting. One last note about all of that is a big theme of what we'll see in here talks about communication. And I really, really want to stress this a lot. When it comes to consumer protection, so many of our laws, so many of our statutes are about how businesses and consumers communicate. And you'll see that as a theme as we go through this presentation. So really broadly, all the things that we do, we have a consumer protection hotline, 1-800-422-7128. One of the most miraculous things about it is that when you call, there's a person there who answers the phone. It's unbelievable. It's an amazing innovation, I know, in today's world. But yes, we figured out how to make it happen. People work in our hotline, they're answering your questions, and they are most likely going to be able to answer your question that you have. No transferring, no moving you on to somebody else. Now, if you got something like, a little extra, a little more like in the weeds, yeah, maybe they'll pass you off to an expert. Maybe somebody like me will actually jump in and answer the call. But for the most part, they're going to be taking care of you, and they do an amazing job at it. We also mediate consumer complaints. We investigate the cases. We take enforcement actions. We educate and inform Wisconsin consumers and businesses. Education is a big part of what we do. That's what I'm doing right now. I have a couple of people from actually our bureau, Ben and Andrew, who are here watching. They're part of their job, part of what they're charged with. And Ben, pretty much almost entirely what he's charged with is making sure that consumers in Wisconsin are aware of our laws and procedures and just how to be a good consumer. We administer the telemarketing do not call law. So that's a big part of our deal. We provide identity theft assistance and education, especially if people are losing money in identity theft case. Somebody else has opened an account, taking bills out in their name, we can help. We administer the security program. That's really the idea is we regulate businesses like gyms and others that take money up front, in order to provide their service. We regulate hazardous consumer products. Of course, we care about product safety, and we have some environmental regulations, including those little numbers and symbols that show up at the bottom of plastic containers that tell you about how they're recyclable or not. With that, the next slide here's our top 10 complaints. So of all of those things, all the things we do, what's at the number one? Well, look at it right there. It's Landlord-Tenant, 2,208 complaints. When you look at our numbers from 2023, this is the second year in a row that Landlord-Tenant has been the number one on our list. And the first year that it's been by this much, which is to say it's more than the second and third category combined. Part of that is a little bit of that is because telemarketing has dropped quite a bit. We've seen sort of like everything from new FCC rules to new things that telecoms are doing, to just that simple thing that says scam likely when you get a phone call that's suggesting that things are happening. So that's a little bit of the change. But however, the thing to know is almost every category went down this last year except for Landlord-Tenant, which went up pretty significantly. And if you were asking me to say why, what's going on, what's happening in the world of landlord-tenant situations, it's causing complaints to increase, I couldn't point to one thing. It's really across the board. So with that, I wish I could just say, oh yeah, it's because of this issue, it's because of that issue. It's not really the case. It's a little bit of everything. And so, but nevertheless, it's something that our group is tackling, handling, and we're out here trying to resolve every one of these complaints that come in. So let me talk about the landlord-tenant laws in Wisconsin. And I need to explain this kind of in a couple ways. First of all, we have these two areas: Wisconsin Statute Chapter 704 and Administrative Code 134. These are two very, very separate sets of laws that at times look very similar or almost identical. The reason why they're separate is because our administrative code is not derived from Chapter 704 at all. What gives DATCP the ability to regulate landlord-tenant law is actually Wisconsin Statute 100.20 in essentially what is consumer protection law. That's why we regulate some things like security deposits and with earnest money, other things like that, but also why we don't regulate things like evictions. We don't really get very much into issues regarding the responsibilities of landlords and tenants. Other things that are in 704, we generally stay away from, and we really want to really emphasize the idea that we don't regulate, that we don't do that. If people are looking to exercise rights that are in Chapter 704, their remedy is essentially through the court system. Those are statutes, those are rights, those are there, but they're outside of our purview. 134, however, comes from us. It's all about what DATCP does. And what you'll notice is sometimes our laws line up perfectly with certain areas of Chapter 704. The final real thing to know about the difference between the two is that violations of administrative code rules in 134 can come with double damages if they're decided in court. That is written essentially into the statute that allows us to have this code. When it comes to violations of Chapter 704, the remedy is essentially fixing whatever damages happened, right? Restitution, but there is no double damage penalty and anything like that. So those are the big two differences. And I'm going to get into 134 here real quick. However, I really want to talk about two areas of 134 that we're not going to get into at all in this slideshow. And that is 134.01 and 02, which talk about our scope and our definitions. These are the first two areas of law. And, forgive me, I get real nerdy about this stuff that everybody just like slides over, just like whatever. I know what words mean. I don't need the definitions. Scope, I don't even know what that is. And then they move right into the meat of the issue, which we're kind of going to do here. But I really want to emphasize that we have a limited scope. There's certain things that ATCP 134 does not cover in landlord-tenant relationships that maybe 704 does. So that's one real important thing to delineate there. The other thing is within the definitions, you can learn a lot about our scope, about what we can cover, about what we can't cover, what makes somebody a landlord and what makes somebody a tenant. You can figure that out through definitions. What you find are situations like if somebody is having maybe just a person stay with them in a room, but they're paying or contributing to rent $100, $200 a month just to stay in the room. They're just a friend that's there. They'll find out that that is a tenant. However, if that person has a primary residence somewhere else, right, and they're just staying but contributing, I don't know, for about a month, let's say, 60 days or less is the rule, then they're not a tenant according to 134. So these little definitions, these things matter. I'm not going to get into the weeds with all of them, but I really want to explain the importance of it in that way. With that, we're going to jump into the meat of it, if you will, and we're going to head right to 134.03. So this says, talks about agreements and receipts. So if there is a written agreement, they have to be provided to the tenant. However, rental agreements can happen all the time. They can be verbal. In that scenario that I talked about, where the person just like, yeah, sure, come stay with me and chip in, I don't know, $200 or whatever, and you can stay with me. That could very well be a rental agreement, especially if that person is not living anywhere else at the time, but rather is staying with you. And the person who is offering that, sure, chip in, whatever, could be quite surprised to find out that they are now a landlord. And if they decide that they don't want that person to live in there anymore, they have to follow all of the rules, including the rules for eviction. I kind of always make this comment that there are two ways that people can find themselves to have great responsibility completely by accident. One is by becoming a parent, and two is by becoming a landlord. So with those two things, you can just find yourself to have to follow a whole lot of new rules that you never even knew that you would have to. So with that, receipts are required. We're going to go into the where they're required for earnest money deposits, security deposits, rent paid in cash, and deposits paid by check when requested. But they're not required if you pay by check. So just a big note about that. There's plenty of people that take money in cash as landlords and aren't giving receipts, but those receipts are really important. And this just starts. This is the first hint of the theme that I want to really talk to you about, which is communication. That receipt is a communication between a landlord and a tenant. And a lot of our laws are about establishing communication, especially through the written record. With that, let's go into 134.04. We're going to go into disclosure. So before entering a rental agreement or accepting earnest money or security deposit from the prospective tenant, the landlord has to disclose building code or housing code violations, right? So once again, this disclosure, think about it in that theme of communication. Landlord is required to communicate these things to the tenant. When it's a situation where there is an actual building code or housing code violation, they have to disclose it, but there are a bunch of factors that go into it, whether they have to or not. First of all, they have to actually know that there is a violation. The violation has to affect the dwelling unit that is what the tenant's going to rent. The violation has to present a significant threat to the prospective tenant's health and safety, and the violation has to not be corrected. So essentially, if there was sort of a violation that was a housing or a building code violation, but it got fixed, then that disclosure is not required anymore. But if it's still out there, it needs to be disclosed if somebody's interested in renting this place. However, that's not it when it comes to disclosure. So whether or not there is notice or a code or anything like that given to the landlord, the landlord has to disclose these conditions that affect the habitability. One is that the dwelling unit lacks hot or cold water. Two, that the heating facilities are not in safe operating condition or can't maintain the temperature in all living areas of at least 67 degrees during all seasons. Those temperatures are measured in the center of the room between the floor and the ceiling. You'll see that's about heat. What does not show up is air conditioning. We do not have anything that says that a room needs to be below a certain temperature or anything that requires air conditioning as a part of our habitability. We'll keep going with these. We got some more. The dwelling unit is not served by electricity, or the electrical wiring outlets fixtures are not in safe operating condition. So that's a big one there. It's been very big in the Milwaukee area recently. Of course, a real issue there is fire hazards. 4 is sort of that catch-all one, and you'll see these show up in codes and statutes where we're talking about everything that's specific that we can think of. So this is any structural or other condition in the dwelling unit which constitutes a substantial hazard to the health or safety of the tenant, or create an unreasonable risk of personal injury as a result of any reasonable foreseeable use of the premises. And that one kind of captures a lot more. The last two on here is a little bit more straightforward. The dwelling is not served by plumbing facilities. The dwelling unit is not served by sewage disposal facilities. And we'll move on to the next one. Just so you know, I am to see if I'm getting chat notifications. So if anybody does want to, kind of like at the end of a slide or whatever, I'm jumping in to see if anybody's written anything in there, has a question. So feel free to do that. So other disclosures besides these habitability issues. Once again, why are we focusing so much on disclosures? First of all, we're talking about communication, right? Disclosures are all about what a landlord needs to communicate to a tenant. But secondly, we're talking about the consumer protection part of these all. If you see, so many of these things are about before entering the rental agreement or before the consumer or the tenant signs up. And that's a real piece to consumer protection, right? The idea that the tenant needs to know what they're getting into before they sign this contractual agreement. All right. And so many of our protections happen in kind of that whirlwind bit of finding an apartment more than when they jump in. I got a question here. I'm going to just jump into it because we had one come in. Back to if the tenant collects money from someone staying with them. Does a landlord need to be aware of this extra tenant? So we're talking about maybe like the stub tenancy, right? So the tenant is collecting money from another tenant, and now that tenant finds himself in the very dubious position of being a tenant and a landlord at the same time. There's nothing that requires a landlord to know. Now, the landlord may become aware of this, and this very well could be a lease violation, right? No subletting. That's a lease violation. That's something where the tenant then can, or the landlord can go towards the tenant who is allowing someone to stay with them for money and say, you can't do this. Maybe give them a notice of eviction if it really comes to it. So that is one route in all of this, but they don't necessarily have any obligation or duty to the law of being aware of the extra tenant, but they do have things that they can do in there. So hopefully that answers that question there. With that, back to our disclosures. This is a good question though. Whoops, let me go back here. There we go. The landlord, these are just other disclosure requirements, right? This idea of communication. The landlord shall disclose in writing at or before the time of the rental agreement, the name and the address of, and there's really two key people here. One is the person or people who are authorized to collect or receive rent and manage, maintain the premises, who can readily be contacted by the tenant. So this could be the landlord, the owner themselves, somebody who works for the property management company. It doesn't have to be any specific person that the tenant designates or wants to be able to talk to. It's just got to be somebody who can handle this situation. The other one, the other person, and then this could be a very different person, the owner of the premises or the other person authorized to accept service, like legal service or other notices on demands on behalf of the owner. So this is really like the key owner and the owner's agent. Now, oftentimes these could be all one person, or it could be the same property management person that handles both, right? But the idea is the tenant needs to be able to know who to call to get something repaired, and they need to know who to contact if they have a legal action that they want to take against the owner. Those two have to absolutely be disclosed, and it's quite important in many different ways that we know who they are. When you look, those after that, we'll talk about utility charges here. That's another disclosure requirement. Before or at the time of the rental agreement, the tenant needs to know that if they're going to get charged for water, for heat, for electricity, it's not included in the rent, they have to disclose that to the tenant before entering the rental agreement, or accepting interest money or security deposit from the prospective tenant. So basically, at the time that the tenant is going to start to have to pay anything to the landlord, the tenant needs to know what the deal is about utilities. Now, when it comes to those disclosures, are there any rules you might ask about how those are determined? Not specifically, not really, no. The deal is that the landlord can split those up in many different ways. So they can do it by square footage, by how many people are in each unit. They can do it just straight across the board to split it in half if it's like a duplex. However, they can do it however they would like. They just got to let the tenant know how they're going to do it, if they're going to do it that way. Let me jump into the chat. Oh, we got a question about items left after moving out, items left behind. That's good stuff. I'm going to probably get into that a little bit later on in the presentation. But I'm gonna address that. And then if you have a specific question about it, let me know when we get there, all right? But don't let me forget to talk about it. Here's what I want to talk about here. This is promises to repair. It's 13407. Once again, we're back into the world of communication. Communication is disclosures, but it's also promises. These I find are very, like, tenants or landlords are always very surprised about these type of things. But man, they sure do fit into consumer protection's role of trying to, once again, make sure that communication is happening and really demonstrating the the promises, and you'll see what I mean about, like, why they want this so concrete. So first of all, every promise or representation has to specify the date or the time period on which the cleaning, repair, improvements are to be completed. That's every promise, no matter what, needs to come with a date. And my piece of this is sort of like, why? Why does it have to have that date? Why can't the promise be enough? Well, if you've ever known anybody who's been engaged to marry in an endless engagement without a wedding date, you will know that a promise is not a promise until you have a date. That's the same thing here. A promise is just not a promise until you say when. If you're not sure when, well, there's a method to that, but you at least need to put down a date so that the tenant has a framework, an idea of what they can work with. And it allows for better communication because they're then less likely to, call you every day about it, and much more likely to call a landlord at the time that, hey, this maybe moved past the date that you said that they would, right? So that's a piece there. Number two, all promises made before the initial rental agreement shall be in writing with a copy furnished to the tenant. That's the concrete part of this. They have to be in writing if it's before the initial agreement. And that's because, once again, consumer protection cares really about protecting that consumer during that time of finding a place, choosing where they want to rent, that they know what they're getting into. So that documentation can really help them. It also can really help a landlord in the sense where a tenant will say, well, hey, this was promised. If it's not in writing, then once again, maybe there was no promise ever given. And then finally, number three, every promise or representation shall be completed within the time period represented, unless a delay is beyond the landlord's control. Delays happen, and delays beyond the and when delays happen, they happen because they're beyond the landlord's control, right? The landlord is supposed to give timely notice to the tenant for the reasons beyond the landlord's control for any delay, and then they should give a new date. They should say, well, it'll be this day instead. So that, to me, sort of establishes that idea that when you are making a promise to repair, you have to give a date. And I am really, really quite honest about it when I say giving those dates really will help out a landlord when they are fielding those constant calls about when is this going to happen? Why has this not happened yet? An analogy that I kind of love to use is when I was a kid, I would always ask my parents, "Are we there yet? Are we there yet? Are we there yet?" 5 minutes into a road trip. Now I have a son. He never asked this question once. Why? Because I have the GPS up and it says exactly when we're going to get there. So he knows not to ask the question, right? When you give a date, you're not going to ask the question. You're not going to get those questions. People are going to know what to expect. So does this apply both before moving in and while in the dwelling? So the promises to repair, the idea that they need a date applies to both. They only have to be in writing. They're only required to be in writing if it's before the initial rental agreement. But even during, when there is a promise to repair, when it says, yes, I'll get over there and do that, there should be a date with it. And there's one more reason in a synergy way, why that really makes sense is because when you do that, and then you also give the date, and not the date by, but the actual date that you're going to do it, well, as long as you are adhering to that date, you're also essentially providing the notice required for entry to make that repair, right? So kind of knocking down two obligations at once at that point. So once again, always makes sense to give that date. All right, and we're going to move on. Earnest money deposits and credit checks. So this is about the money that a tenant gives a landlord to be able to enter into a rental agreement. We would call that an earnest money deposit. The thing to know about it is that any money that is given from a tenant to a landlord in it for the ability to enter a rental agreement is earnest money by definition. Any money. All right. There is no such thing as non-refundable application fees. There are no such things as non-refundable earnest money deposits. Nothing like that. It all goes under earnest money and is subject to the rules of earnest money. And so that is a really, really key component to understanding what it means when a landlord is taking money before when a landlord is taking money before a tenant enters into the rental agreement. So a lot of times this money is given with an application, right? And the application is then going to be reviewed, accepted, rejected by the landlord. The landlord has a very limited amount of time, 3 days, to decide, right? If they're going to accept this or deny it. When there's earnest money involved, right? They can't sit on that application forever. And then when they do decide that they're going to accept or deny the tenant, they have to do something with that money within the next business day. If they decide that they do not want to have this person be their tenant, they need to give it back within the next business day. If they do decide that they're going to have them as a tenant, it can become security deposit, or it can go to first month rent, but it can be credited to them, or you could give it back to the tenant. But so those are the options if it's accepted. Something that's sitting here at the bottom here that everybody's noticing is credit checks. So wait, you said that it's all earnest money. So what about this credit check thing? So I have to give all the credit check money back? No, there is an exception about credit checks when it comes to earnest money, which is to say that a landlord can keep up to $25 for a credit check, and they do not have to reimburse that money. However, it's not just a flat $25. It's $25 or less, whatever the amount actually was that they spent to do the credit check. And when a landlord does that credit check, they have to give a copy of that credit check to the tenant. Also, if the tenant has their own credit check, they can give that to a landlord, and then the landlord cannot charge them for a credit check in a way that keeps that money. So that's the rules. The credit check, I think, has to be like 30 days. It has to be like within 30 days, right? So they can't keep a really old credit check. It has to be recent. But those are the rules for those credit check parts. Now withholding earnest money deposits, right? When a tenant gives the landlord that money and that application, they're saying they want to live there, right? And at that point, the landlord has the option to accept them, reject them, do their procedure to it. But after that money is given to the landlord, the tenant cannot, if the tenant were to withdraw their application, they don't want to live there anymore. There is a potential that damages may exist because the landlord now has to find a new renter. And has to advertise for a new renter. So the landlord is allowed to withhold the amount of money that it takes to find a new renter if they have to re-advertise it, or if things really extend out and they can't find a new renter and it's moving into the time period where the tenant was due to move in and they haven't found anybody to move into that place, they can start to withhold for rent as well. So they can withhold that money for that. It's sort of like the same rules as breaking a lease. They can only withhold the amount of damages that they incurred, and then they have to return the rest. That's my bit on security deposits and credit checks. I don't know if anybody else has any questions about that. Otherwise, we're going to move on to the next one. Oh, I got something up here. So charging an application fee not allowed. It is earnest money. So it is certainly, it doesn't matter what you call it, is really what I want to get at with it. It's considered earnest money, and so it needs to be taken care of the way that earnest money is taken care of, which is to say, returned if that person is not accepted, or applied to security deposit, rent, et cetera, if they are accepted. Let's see, and then this is a question here. We withhold 1 month security deposit if someone does not move in because the management company charges us 1 month to re-rent the unit. Is that okay? So that's sorry about that. That's an interesting question. Because we're talking about how damages are calculated when we're talking about what that charge is. The question is, all the way along the line, what is the actual loss? What is the actual damage in this place? Now, between a landlord and a management company, we at Consumer Protection kind of consider you all the same unit. And that is because, once again, those definitions that we all like to skip over at the start of it. We consider a landlord and a management company to essentially be one. And so if it actually costs the management company that much money to re-rent the unit, and they can demonstrate it in that situation, then it may be okay. Otherwise, we might say, look, if your management company is charging you that much to do that, but they're profiting off of it, maybe you need to find a new management company. So that's where we kind of look at that piece. So that's between you and your management company to some extent. However, if the management company, or if you can actually say that that is how much money that as a group, as all of you lost as a part of this, then you can do that. One last bit of it, I'm always very skeptical of flat fees for breaking leases or for withholding earnest money, because it's likely that flat fee is not representative of actual damages. And everything that we calculate and all of this stuff, goes back to the old-timey common law contract stuff. When contracts are broken, we're looking at actual damages to really figure out what money needs to go where and how much. All right. And I'm going to move to the next slide.
Aaron, before we step away,
Hey,
there was just a follow-up.
Oh, I'm sorry, did I miss it?
Yeah, if you just want to read that, just in case it is just pertaining to that.
Oh, sure. Yeah, I just missed that. I'm sorry. Yeah, the tenant signs a holding agreement, agreeing to the withholding prior to us taking any money. So they don't have, there's been no money paid, right? But then my guess is something happens where this is sort of like a rental agreement or like an agreement to join a rental agreement. I would probably have to look at the specific situation and the specific way that holding agreement is written to like make a really good assessment about how that all is. However, because there's a couple things to it. One is, so you do that and then maybe they don't. And so then you send them a bill and then maybe they pay for it or they don't. So there's a lot of different ways about how that could be broken down when it comes to those type of agreements. because there isn't really any earnest money to be withheld. But however, we have a situation instead where where somebody is aggrieved and has to pay somebody else something. It really depends on how that contract language looks, because we're talking about, once again, contract common law type of stuff. So gonna have to unfortunately kind of punt a little bit on that one, but it's a little bit of your results may vary really based on how that is written. All right. But we're kind of like moving right into kind of like a good zone in the same sense, because we're going to talk about security deposits next. Security deposits are the earnest money of after the rental situation instead of the start, I guess. So there's a few things to know about security deposits. One is that there are check-in procedures that are outlined a little bit in 134 and then somewhat in 704 as well. The tenant essentially has a right to do a couple of things, including inspect the unit and submit a what would be sort of an intake of the condition of that unit. They also have the right, and this one doesn't show up a whole lot, but they have the right to request what was withheld, what was the damages that were withheld in from the previous tenant. Not the amount of money that was held, but what damages there were. The reason for that is to essentially make sure that the landlord isn't withholding for the same thing every year. They come in, they see that the screen door is got a broken screen, and they look at it and they see, well, hey, it looks like this was noted last year, like for the previous tenant, as a withholding from them. Why did you not apply that money to this screen? So it's a little bit of check on to make sure that everybody is being straightforward in that process. So that's a little caveat in the check-in procedures. When it comes to returning deposits, there are, of course, rules about that. The rule that everybody knows is that security deposits have to be returned 21 days. When I say 21 days, what you should all think is, what does that mean? It really actually doesn't mean much until you start talking about 21 days after what, right? For most cases, it's going to be 21 days after the tenant moves out. If the tenant moved out under a normal circumstance at the end of the term, or after agreed upon termination of the month-to-month, however you want to put it, it's 21 days after that. However, there's a lot of other things that can happen, right? What happens if the tenant breaks the lease? Well, they're not owed 21 days immediately after breaking the lease or 21 days after moving out. They're actually owed that security deposit 21 days after a new tenant moves in. So if they're on a term, you can't wait till the complete end of the term either. It's 21 days after the next one moves in. If a tenant moves out and the landlord doesn't really know when the tenant moved out, which can certainly happen, then it's pretty much going to be 21 days after the tenant is, or the landlord is made aware that the tenant has been moved out. So there are some caveats in all of that. With returning of the security deposit, most of the contention is not about what needs to be returned, but what is withheld. And so in the rules of withholding, there are rules about specifically the type of things that can be withheld. The main area is going to be damage, neglect, or waste, right? Damages to the apartment are the main thing that's being withheld for security deposits, but other things including unpaid rent, unpaid utility bills, and some other costs can be deducted as well. The biggest thing, and the thing that, once again, consumer protection is really concerned about, is that communication about it, right? So when there is a withholding, there needs to be a statement of claims, and that statement of claims really needs to clearly communicate to the tenant what is being withheld and how much money for like what damage happened and how much money is being withheld to fix that damage. No more money can be withheld than what it takes to fix it. And there is some movement, some area of sort of like, well, it needs to be for that actual damage, but if you don't know exactly how much that's going to cost, it needs to be a reasonable amount to cover it, right? So regardless of knowing the exact price, let's say that, you know, it's a broken window and you don't know exactly what the bill is going to be on it yet. You can think about what it is that has been reasonably charged to replace that and withhold that. So it's a reasonable amount. The reason why we say that is because sometimes landlords don't want to hit that 21-day mark because they're like, I'm not sure exactly how much this is going to cost, and I want to be able to recoup it. Don't focus on exact, focus on reasonable, but no more, no less than anything that would be considered reasonable. One thing that cannot be withheld from a security deposit is routine wear and tear. I get so many questions all the time asking me, what does that mean? And I don't have really great answers for it, but I like to tell you a little bit about how I kind of conceptualize it as a way, and the questions that I ask if cases like this come to me. First of all, there's bound to be wear and tear in a unit when a person lives there. And so it cannot be a requirement that a tenant leave an apartment in the same condition that they entered it in. To give you an extreme example of this, if somebody lived in an apartment for 20 years, there is no way that under any reasonable circumstance, a carpeting in that apartment should be the same pristineness 20 years later as it was new. Carpet's meant to be walked on, carpet's meant to be worn down, carpet is meant to be replaced. So that's a situation where, hey, okay, that's wear and tear. That's not going to be damage that can be assessed to the tenant. And so it's something I ask landlords if I'm sort of concerned about, hey, how withholding looks like is when I see things for replacement or for cleaning or things like that, especially cleaning, I'll ask a landlord, how much is the normal cost that your staff or whatever service that you get, how much is the normal amount of money that you spend on sort of cleaning? And then how much above and beyond that is this apartment a situation, right? Because there's going to be a certain amount of wear and tear that comes in a way where things need to be cleaned to a spick and span level. People have expectations when they move into a new unit that it be at a certain level, but that certain level is not the level that somebody sort of lives in, that somebody sort of normally sort of goes through life doing. I do not have my carpets professionally cleaned once a year. And so I don't think that there'd be any reason why under a normal living circumstance that a tenant would be required to, as they move from unit year to year, need to professionally clean those carpets every year. However, if they did damage to the carpet in a way that was beyond sort of just living in it, then that damage could be withheld for. That so back to my question, I'm always asking, hey, this is it looks like you are withholding for cleaning. How much above are you charging? How much above, or how much above were you charged? How much above the normal, your normal costs were incurred by this? That's one piece to it. That's 134.06.3c. There's then the second part, and just important to us, is the communication part. If there is cleaning, or if there is a carpet repair, or if there is something that happened to a wall that is damaged, that is above routine wear and tear, it needs to be articulated in that statement of claims. It needs to be written out with how much money is going to be withheld for that. And that really is because that communication between the landlord and the tenant when it's good, stops things from going to court, and it stops things from coming to us, and it stops making a whole lot of extra and unnecessary conflict between a landlord and the tenant. The better the communication that is, if the tenant sees, hey, you're cleaning my carpet and you're charging me, the tenant's going to say, I know my rights. Carpet cleaning can't be withheld for. But if that statement says carpet is cleaning for large stain in the middle of the living room, the tenant can say, oh, yes, that stain. I can see how that's damage. I can see how that's not routine. Maybe I don't have the claim there. So that communication is really what about the statement of claims is all about. And one last note, in this zone, you'll see we're talking about forwarding addresses. And I'm going to get to the questions in just a bit. The forwarding addresses part, the rule as we have it now is we do a lot of communicating with tenants. We do a lot of these presentations where it's like, leave your forwarding address, leave your forwarding address. The landlord will use your forwarding address if you leave your forwarding address. Landlords, if you have a forwarding address, send it to that. If you don't, you send it to the last one that you know, right? You can't just hold it because you don't know where they moved to or anything like that. Maybe they have something set up right where there's an automatic forwarding thing from the unit or whatever, but you send it to whatever the last address that you have, and you hope that the tenant gets it. Let me jump in here and take a look at the chat here. We got, why is there an expectation that we need to completely repaint a unit if a person moves out after only a year there? I don't know if there's necessarily that expectation that a unit needs to be repainted if they've only lived there a year. Certainly that expectation doesn't come from consumer protection. It's all about how things are marketed and how things are shown. So for instance, if you are showing a show unit where the walls are immaculate, and then when they get into their actual unit, the walls are really dingy and definitely need repainting, and there's probably a misrepresentation there. But people just need to know what they're sort of getting into. And if people are expecting a complete spick and span unit because that's what's been shown to them in photos and what's been shown into them in a model unit, then it needs to be there in a different, or if it's been promised to them, if there's say, hey, we're going to repaint this, then that needs to happen. But a lot of tours, a lot of things that are shown, they're showing apartments while people live there, right? And so there's a little bit of like, hey, there's an understanding about what condition that place is at that point. So hopefully that answers the question there, but I just really want to make clear that there is we don't have that expectation. But just to follow up on that, I don't think we can charge for paint, but people leave their units in a condition after only 1 year that requires paint. From our Bureau's perspective, if you can articulate the damage, if you can tell me what has happened to those walls where it needs paint, and do it in a way where it explains sort of most likely in a room by room situation or something. Sometimes smoking can be so bad in a unit where you got to repaint a whole lot, or sometimes there can be so many scuff marks in certain area, but just articulate where the scuff marks are, show where the things are. As long as it is articulated, then it could be something that would be considered damage and something that a tenant could that a tenant would be essentially on the hook for. I'm going to jump to this other question. If a landlord performs their own cleaning repairs, are they able to charge an hourly rate that is customary of what a commercial contractor would charge? That's an interesting question. We don't have any laws that talk about what the actual rates are, what anything is sort of like that in that sort of bit. But if they are repairing damage, they're allowed to withhold whatever it is to make it, whatever it actually costs them to make it whole again, right? So no profit on top of that. Now that's a big piece to it. So you can't make money off of repairing the unit back to its original self. You can only go back to, you can only charge as much as what it costs to actually do it. Now, does that include like sort of like the man hours to do it and the stuff that you sort of like lost doing something, excuse me, something somewhere else because you're doing that? Yeah, you know, that's there. So, you know, you can make that its own way. But that's it. That's key, is that you can't charge anything that sort of puts anything beyond what makes you whole for that happening. Yeah, and then we just got a comment down here. Pictures and videos prior to move in and video and pictures when they move out is a great tool. Absolutely agree. It can very, very much help in court. I would say that those pictures and those videos, once again, they are examples of good communication methods. Something in the sense that oftentimes I'll see those pictures shared with the tenant with the security deposit withholding statement. And, you know, this is, once again, only practical talk and no laws about it, but sharing something like that with a tenant could create a better communication situation where the tenant recognizes what you're talking about when you're talking about damage. On our end, you know, when we're evaluating these cases and things like that, we're not judges in our unit. We don't look at it and be like, oh, no, that's damage. It's like, oh, no, that's routine. We don't really have the tools to weigh that. And because we don't weigh it, we don't really evaluate pictures in the same way that maybe a judge does, right? Judge, you know, they're called judges, right? So I guess they judge that stuff. We don't. We're mediators. We say, you guys, let's see if you can agree on what this is or not, right? So it's a little different between us and them on it. But yeah, Mike makes a great point about that. That's my bit on security deposits. I don't know if there's anything else on that. Otherwise, we'll move on. Okay, I'm going to get into some areas that are maybe not within 134, but areas that affect how we do some things in our ATCP 134 for consumer protection. So what you'll see here is one thing is talking about certain things that happen on a 1-year lease versus a month-to-month lease. Specifically 704.17 and 704.19 talk about the rules for notices and terminating those leases. So in a 1-year lease, obviously what you have is a term, and it ends at the end that it says in there. The tenant is expected to vacate at the end of the lease. Sometimes term leases have notices in it, and this has always kind of struck me as a little, or notice requirements. This always struck me as a little odd because, like, you know, it's the end date is right there in the lease. Like, I don't know why anybody would need any more notice. Everybody sort of is already on the same page about when that's happening. The exception to that has to do with automatic renewal, which is to say that if they don't, what is the penalty if the notice isn't given? Is it that they are automatically assumed to stay there longer? Because if that's the idea, then we're talking about automatic renewal, and there's some special laws about that. I'll get that into a second. But generally speaking, when a lease ends on a term lease, it's got an end date. That's it for everybody, right? Of course, a landlord can't raise rent during the lease, and they really can't change any sort of terms in the lease either. That's a contract that's sort of agreed upon at that time, and changes have to be agreed upon by everybody. This automatic lease renewal, I talk about it. We see this a little bit here and that. The thing to know is if there is an automatic renewal sort of situation where a landlord is requiring this idea that lease go beyond the term, right? So it's like sort of like this will go to month if this lease will go to month if we don't receive notice from the tenant. right? Wherever that notice requirement kicks in, the landlord needs to remind the tenant that essentially they've got 15 to 30 days to decide before it's gonna kick out. I'll get into that a little bit more precisely in a little bit, but that's kind of this idea of the automatic lease renewal. We see these a lot of 60-day notices. If no notice is given and the landlord continues to accept payment after the lease term, it becomes month to month. That's just sort of how this is. A lot of times leases, they have this end date, the tenant stays, but then the landlord accepts rent. So what is this now? Well, that is sort of stipulated in 704 what that is. It's now a month to month where all of the rules of the regular year-long tenancy stick. But now they're just on month to month rules. And that happens quite a bit. So if the tenant is, if you want the tenant out, but you accept rent, you're going to find that, well, they're signed up at least for another month. And now you're in the world of month-to-month tenancies. So in month-to-month tenancies, any party can end a tenancy with a notice prior to the rent being due. And so it's all based on the idea of 28-day notices, because that is the shortest month that really exists. That's the default in 704.19. So notices to terminate tenancy or notices to by either party can be done in 28 days. Requirements that, and this is where things get a little tricky, requirements that tenants give more than 28 days notice to end a tenancy become problematic within the rules of consumer protection, because tenants start to get locked into more than one a period in a periodic tenancy. And when you're locked into more than one period in a periodic tenancy, are you even in a periodic tenancy anymore? Especially because what happens if the landlord were to raise rent in the middle of that period, one period to the next? Is the tenant in violation by not giving enough notice before they could move out, or are they on the hook for that raised rent? So those are, because of those problems, the periodic tenancy is something that we consider 28 days at a time, or 28-day notices at a time. There's a question here. Let me take a look at, see what this is. Oh, it's Ben. He's just sort of talking about this. Just the idea that, it's going back to this about, Ben just had a comment about doing, recording things before moving in, before moving out. He's recommending that tenants video the entire dwelling before moving anything. And the idea, yeah, that it's relational, the idea that, we all want to be on the same page. So that's a little bit about the 1-year lease versus the month-to-month thing. It's 704 things. We don't have a lot to enforce these things one way or the other, but we want to make you aware of it, because we do start to, those rules and our rules do start to intersect in certain areas. But here, I want to get into the prohibited rental agreement provisions, 134.08. These are the thou shall nots that are within our laws. They also exist in 704. There are actually 10 or 11 of them. Actually, the way you count them, there might be 16 or 17, but I'm going to highlight some of the biggest ones. Increase rent, decrease services, refuse to renew, bring in action for possession because the tenant has contacted law enforcement, health or safety services. You cannot have this as a lease provision. It's prohibited. If we were to use this as a lease provision, what you would find is that this is something that makes the entire lease void and unenforceable. That's the same for everyone that we're looking at here. The whole lease gets thrown out if it has anything in here. Another one that's prohibited is unlawful eviction procedures, basically saying that the landlord has a right to evict the tenant by any other route than going through a judge or through eviction court. Not allowed. I'm going to get to acceleration of rent in a bit, because that is probably our most popular one out of all of these. Requirement payment of attorney's fees. So a landlord cannot require a tenant to pay the attorney's fees for a landlord if there's a action, like a legal action brought about by either party. They cannot say, hey, because this action happened, you now have to pay the landlord's attorney's fees. The tenant can still find themselves on the hook for attorney's fees, but the way that they would do that is through a judge order, not through a contractual obligation in the lease. Waiving or transferring liability or legal possession for certain items. So a big thing about that is tenants or landlords cannot make like a unit sort of like a as is, or sort of just say, look, if the pipes break, that's your problem, or like you can rent this place, but I'm not going to fix anything. That is not allowed. That is also absolutely prohibited within the rental agreements. The unlawful termination of tenancy related to certain crimes. Really what we're talking about in this area has to do with domestic abuse protections. Can't evict people for being the victim of a crime. And when that person is a victim of a domestic abuse crime, they have the option of either staying or having or leaving, right? They can stay, they can and have the abuser leave, or they can leave. So there are provisions that protect that area as well. And let me jump up to the chat here real quick. There's a rule that states, this is going to go back to the notices thing, and that's fine. We'll talk about this. Let's talk about this a little bit, because we'll talk about acceleration of rent at this point too. These two things kind of run into each other. There's a rule that states that there needs to be a minimum of 28-day notice. To us, that meant that we could require a 60-day notice prior to move out on a month-to-month lease. So if we saw, what I will tell you is at Consumer Protection, if we saw a lease that required a 60-day notice prior to move out, we would actually declare that a violation of 134.083, acceleration of rent or failure to mitigate damages, and make the entire lease void and unenforceable. And that's something that is kind of a big, like what's going on there a little bit, what's the thinking, what's happening with that. So the deal for that is I submit to you the tenant who I'll get to the jail one in a question. I'm a little curious about that. Anyway, I'll submit to you this part about the 28-day notice. Okay, so here's the idea. Person's on a month-to-month lease. They sign up on December 31st, and they move in January 1st, right? And they would like to move out on January 31st, right? But they find that they can't. They're on a periodic tenancy, but they can't, because they are already obligated just simply by agreeing to move in to stay for 2 periods. Our consumer protection law says that that obligation, that in a periodic tenancy that they can't even stay for one period only, is an acceleration of rent. The idea is they are now suddenly on the hook for 2 periods and could never do it for 1 period. And so by the framework of that, they can't be required to give 60-day notices, because they couldn't give 60 days notice, right? They'd have to give you notice before they even found the place or entered into the rental agreement. It would be impossible for them to do that. So that's the extreme measure that I kind of use to explain this idea of what it means for a tenant to be on the hook for more than 1 period at a time. The requirement for a 60-day notice versus the provision of a 60-day notice are 2 different things. A tenant could tell you 60 days in advance that they're going to move out in 2 months, right? They could give that notice that far away, but requiring it makes them contractually obligated to stay for one extra period. And that is why that is not allowed. And so that's why we, the minimum thing is there. I understand this idea of why 60 days are there, like, and why I see this so much in so many places. And that is because 28 days is a ridiculously short turnaround time for a landlord to find a new tenant. I want to submit in the other direction that it is also a ridiculously short amount of time for a tenant to find a new place to live. So between those two things, I understand why this urge for 60 days exists. And here's, if you really want that time, if you really want it to be 60 days, there's a solution to it, but it's one that nobody's ever going to take, which is to say, make the periods 60 days long, make them 2 months long, make rent due every 2 months. If you make rent due every 2 months, then that period is the requirement for notice, and that is under state statute. So, and it moves in the other direction. If it's actually a week, if the periods are a week, the notice could be a week, right? So if you really want it to 60 days, make the period 60 days, but that means rent is paid, every 2 months. So that's the part where, I want to sort of get into that bit. So hopefully that does my best to explain it. It's a sort of to do it in the legal way, we would have to take a tour through 8 different laws. Don't really want to necessarily go on the tour right now of it, but hopefully the practical explanation is enough to sort of explain what the thinking is there. I have this question: as your tenant gets put in jail for 2 years, and I'm a little confused because I'm not. Terry, if you want to provide any context, that'd help. Otherwise, I'm not really sure. I don't have any tenants that are in jail for 2 years. The next thing I have is in a rental agreement, is it acceptable, legal to require the tenant to keep charged batteries and a smoke carbon monoxide detectors, or to inform the landlord immediately if the detectors are not working? So that's going to be 704 stuff that talks about landlord responsibilities and tenant responsibilities. So kind of the things that I'm not I can't really got to get into about what responsibilities have one way or the other, or are one way or the other. However, what I can see is sort of when I've seen those type of things in leases from consumer protection aspect, there's a certain amount of maintenance that a tenant is sort of normally expected to do as part of upkeep, or to not have waste, damage, or neglect happen to the place, right? And so would that fall underneath that? From a practical standpoint, I'd say, yeah, it's not really articulated, I don't think, anywhere in the law specifically, but I'm happy to talk about that practically and say that such a requirement would not it's not at the same level as, for instance, somebody requiring a tenant to repair their own broken I don't know, front door, right? Or if something were to if the water heater breaks, they're not going to be required to repair that, right? So if they in the other direction, if it's their damage that causes it, they're on the hook for it, but they can't be necessarily required to repair it. Yeah, back to this early termination agreements fit in with the acceleration and mitigation clause. Many tenants request an early termination agreement to get out of a lease, but that means a buyout, really, and no mitigation. Otherwise, why would the landlord agree to it? Early termination agreements, where basically the landlord and the tenant get together and agree that they're going to throw out the old rental agreement and make a new one that has different money involved and a different end date. Those are things where there's no laws against that when it comes to sort of consumer protection stuff, right? So we're at that point, we're talking about landlords and tenants. We're talking about 2 people in a contractual agreement, or agreeing to end that contractual agreement, start a new one. And so oftentimes you see that kind of thing. We see that quite a bit where the tenant just wants to know exactly what they're paying, right? They're going to be like, look, I don't want to be on the hook for potentially months and months of rent. I just want to pay this amount of money and then not think about it again. And the landlord's like happy to oblige by that. They're like, okay, that's fine. Be out by this day. And, it puts me on the spot, but I'll be able to find somebody, right? That's something that we see all the time. Don't really have any necessarily any concerns with it. If a lease required that and only that, and said that like essentially like breaking a lease is not allowed, you must do this early termination agreement where you have to pay a whole lot of money, that's where we would run into the acceleration of rent or failing to mitigate damages rules of ATCP 134. That failing to, so there are rules that say, hey, that talk about how damages have to be mitigated. The idea that a landlord, once again, can't make money or any sort of profit off of a tenant moving out. They can only assess damages, and they need to try to re-rent the place, and they can only really charge the tenant the amount of money it takes to try to re-rent it, plus the rent lost. That's what the mitigation of the mitigating damages rules say. Ours says, if you say that our rule says, if a lease requires something else, like I'm not going to find a new renter until you pay me $500, or there is no such thing as breaking the lease, you must pay me $1,000, and then the lease ends. Those are not permissible because they're not following the rules of how we would mitigate damages. Hey, we got really great questions coming in on the chat. I really do appreciate it. It keeps me rolling, that is for sure. All right, we're going to try to keep going through this as fast as we can. I swear we're getting near the end. Few more thou shall nots. The prohibited practices of everything. Can't advertise or rent condemned premises. If something is placard, it cannot be rented. We have all sorts of rules on unauthorized entry. Those rules indicate how long or how much time by default a landlord needs to give tenant before they can enter. That notice needs to be 12 hours. They also can only enter during reasonable times. Excuse me a second. And they can only enter for specific reasons, really to show the place, to inspect the place, or to make repairs. And anytime they enter, they got to knock and let the tenant know who they are. I'm going to jump in the chat real quick here. I'm going to answer Terry's question towards the end because it's sort of an interesting, nuanced one. Automatic lease renewal without notice. So this is where we get into this idea that, hey, this term lease says that unless the tenant notifies us 60 days in advance that they are moving out, this term lease becomes a month-to-month lease. Wow. If a lease has that in it, the tenant has to, or the landlord then has to, 15 to 30 days before that 60 days. So if you do the math, 75 to 90 days before the end of the term, they have to tell the tenant, hey, remember that the lease has this provision and you got to let us know 60 days before. So it's always 15 to 30 days before that provision kicks into effect, that automatic lease renewal provision kicks in effect, right? 15 to 30 days before, the landlord's required to let the tenant know that that's coming up so it doesn't sort of catch the tenant off guard. Failure to delivery of the premises. The idea is premises is to be ready for the tenant to move into. If it's not, that's going to be a violation of our code. The tenant can get damages as a result of that if they have to put up in a hotel. And remember, it could be double damages, so they could be charging it twice that hotel rate until they can move in. Next, unauthorized late rental fees and penalties. The biggest thing that I always want to really talk about when it comes to rental fees and penalties is the idea that rental fee cannot, you cannot charge a late fee for a late fee. And where I see this mistake sort of happen all the time is that there'll be somebody will be late on rent and they'll get charged a late fee. And the tenant will pay the rent the next month, but not pay the late fee that next month. And then they'll get another late fee because the amount that was designated for rent, that chunk, pays for almost all the rent, but then covers the late fee, and it makes them incomplete for the next month rent. And so suddenly now they have another late fee. That's prohibited. That's just not allowed. And so we don't want to, that's a big out on that. Unlawful retaliatory self-help evictions. You cannot retaliate. You cannot do it like an eviction notice or a non-renewal for retaliation for a tenant exercising your rights or doing things like contacting a business or contacting what would be like somebody that's inspecting the unit, the city, the health inspector, the building code inspector, or contacting us. Cannot non-renew because of that. Self-help evictions, talk about what would be constructive eviction is another word for that. Can't do things like what was done in the Old West, where you kind of like smoke them out, or you can't turn off the utilities, you can't lock them out, you can't change the locks. Evictions need to happen through the court proceedings. And then finally, misrepresentations. Those are 13409. You cannot misrepresent the amount of, you can't misrepresent the unit. That's one thing. You can't show a fancier show unit than what is the regular one. But you also can't misrepresent the amount of rent charges or non-rent charges that make the overall rent more expensive. Where we're seeing this a lot is in the idea of fees for portals. So if a landlord requires a tenant to pay, the rent through a portal, and that portal has a fee, and that's the only way that the tenant can pay the rent, then that fee needs to be included on the rent every time that the rent is listed, like in any listing, in any advertisement. It needs to include that fee. Otherwise, you're not being honest about how much money it takes to actually rent that place. Even if it's not money that's going to the landlord, it's still money that the tenant has to pay in order to stay there. And so that's one area where that needs to be disclosed, that needs to be represented. Any other sort of hidden fees, anything like that, any extra sort of costs that are going to be required in order for the tenant to stay at the premises need to be disclosed every single time that rent is disclosed when advertising it. Sometimes things get negotiated out later. Like for instance, pets are okay, but then, hey, oh, you want a pet? That's fine, but it's actually an extra $30 a month. That's okay because, unless, in general, you could rent that without a pet and hit the actual normal rent fee as listed. But if it is impossible to take that unit for the fee, for the amount of money that is listed in rent, we're going to consider that a misrepresentation. Let me jump into the chat here really quick. Yeah, let's see. I got, let me just answer this one real quick. How much is a cap for a late fee per month? There is no cap for a late fee by any law. Judges, if you get to court and you're trying to collect late fees that feel like exuberant, for instance, I have, believe it or not, seen late fees that talk about like it's $1 for the first day, but then it doubles every day. People who know how math works will realize how ridiculous that becomes after like a month. So things like that are not, judges just probably aren't going to accept, but there isn't any really law that caps it. Yeah, as we're moving on through it, we're getting close to the end. I'm just going to speak really briefly about evictions. Evictions are covered in 704 and 799. 799 is essentially small claims court. All eviction actions are considered small claims. They are not mediated by consumer protection, and ATCP doesn't really have too much to say about evictions at all. Big thing to note is that there's 5-day and 14-day requirements for notices. They depend on what kind of lease you have. Term leases are almost always going to require a 5-day notice with a right to cure to start with. Repeated violations can lead to the opportunity for a 14-day with no right to cure. Meanwhile, in a month-to-month lease, 14 days with a no right to cure become an option right away. Of course, the 5-day is always there as well. So want to just briefly touch on that. But once again, evictions kind of sit in 704, and we'll kind of leave that where that is. A couple notes about breaking a lease early and holding over. If a tenant vacates a premises before the end of the lease, the landlord continues to charge rent to the end of that lease. They're essentially on the hook for that until it is re-rented. In the other direction, if a tenant stays in the apartment after they're supposed to vacate, it can be considered a holdover. This is also covered in 704. Landlords can charge double the rent to holdover tenants, is prorated on a daily basis. That's essentially what the tenant becomes responsible for holding over. This is really important in two directions. First of all, it's not just extra rent, it is that double amount. Because it kind of makes sense in damages wise, because you're now concerned with both the fact that this person is staying there, so they need to pay, but then also what's happening maybe to the people that are supposed to move in. The landlord is probably doing something to help them out because they have an obligation to deliver the premises. And so maybe they are paying for a hotel somewhere else. The other key thing about this is it is prorated on a daily basis. If somebody stays over an extra day, they would not owe that extra month's worth of rent, right? It doesn't turn into a whole new month. It just becomes a day double rent prorated. Question, can a landlord personally deliver a 5-day notice, or is a professional process server required? 5-day notices can be personally delivered. When we talk about those professional process servers, we're talking about summons to go to court. Once again, this is sort of 704, 799 stuff, but when we're talking about the idea of getting someone into court, that's a little bit of a check your local listings with your local court about what all of those processes are and what they want to see. But generally speaking, that's a different procedure than giving a 5-day notice. All right, then really quickly here, moving out of all of landlord-tenant law and into what happens at DATCP and what do we do with all of this stuff. So we get over 10,000 complaints a year. As you can see, over 2,000 of them are landlord-tenant complaints. When we receive them, I am in charge of a team of mediators. We got 12 people. We analyze, we look at them. We're looking at them for two reasons. One, we want to see if there's any possible violations that are happening here. Let the landlord know about them. We give them a chance to sort of respond to them, deny that they're happening, or kind of show us what's kind of going on. But secondly, we're also trying to open up a communication channel. Once again, really important consumer protection between the landlord and the tenant. We want them to be able to talk to each other, possibly in a new way that they haven't been before, which is to say, one, in writing, we do everything in writing, and number two, with the state government reading it all. So sometimes things that are very uncivil text messages and phone conversations turn into a little bit more civil discourse through our process. So it's an opportunity maybe to find resolution, and we explore the facts a little bit there. And then we'll review it all, and if it looks like what we have here is a code violation, we're going to let the landlord know about it. In our stage in review process, we really are heavy on education, and I really care about making sure that when we get we have a violation, that the landlord sort of understands it so they don't repeat it. Usually everybody kind of gets understands that, takes the education for what it is. Sometimes we have people who don't, who think, well, I know what I'm doing. I don't think these guys know what they're doing. And sooner or later, the conversations get a little bit more focused on, okay, so what does enforcement look like? And enforcement can go in a lot of different directions. But for the most part, when complaints are filed, the first thing that we're really looking at is a way to resolve it between that tenant and that landlord, and to make sure that everybody's aware of the laws that are involved. All right. And I think I'm at the end. These are our resources, and I'm going to talk a little bit. We always have landlord-tenant guides, rights and responsibilities, copies of laws. You can contact the Bureau of Consumer Protection and find any of that stuff out. Visit our website. You'll see that here at the end. I'm going to just bust through here to the end. So you got that contact information, and answer this question and some other questions, and then we'll wrap it up. I was hoping for an hour and a half. Yeah, we're like 3 minutes over. I think we did okay with that, but I want to get to your questions as well. I read that in Wisconsin, an eviction stays on a person's record for 20 years, 5 years if found to be no fault. Could you speak to this briefly? Are there alternatives to having this long-term record? Is that county by county? Eviction there are changes in going into effect about how long those are. So what I can tell you is I don't believe it is that long anymore that evictions stay on a person's record. But it is true that there's a difference between what I would say an eviction and then a stipulated dismissal. That might be the no fault part about it. A stipulated dismissal has a much shorter lifespan than regular eviction on CCAP. I should put it that way. What's accessible online. And there are options. There are things that could happen differently. One of the main things is that there are different legal groups and different websites that can help tenants sort of clear that up on CCAP, especially for those where there's a dismissal or a stipulated dismissal, to clean that off of their record. It is true that for many people, having that on your record can make it more difficult to rent. Now you'll find landlords kind of say, well, this is a sort of helpful. It's important for a background check to be able to know who to rent to or who not to. So there's arguments about that in every direction, but there's probably is a balance there. I don't know how helpful an eviction 15 years ago is versus one that happened 6 months ago. Items that a tenant leaves behind, and I want to kind of get into that and what that all means. So items left behind is really an area covered by 704. What I would talk about with it is when it comes to what's left behind, it's really about what's in the lease. That is going to dictate what a tenant or what a landlord can do with it. If the lease says that when a property is abandoned or a tenant has moved out or passed their rental agreement and there's property left behind, the landlord can pretty much do with that property what the lease says that the landlord will do with that property. They have to follow what's in the lease, but it can be whatever it's in there. If it's not in the lease at all, if there is no lease agreement that talks about stuff that is left behind, then I'm gonna have to, there are many steps and caveats to it. You're going to want to consult Chapter 704 to kind of learn a little bit about what those are. If it is substantial, you may want to contact an attorney. One thing to always know is that a tenant needs to be able to have any medical equipment or medical, like prescriptions, anything that's left behind, no matter what, can't throw those away. Got to keep those for the tenant. Harry, you had a question about kind of a little bit earlier too, about this idea of so you have somebody who's in jail, how do you get the unit back? Well, it has to do with the idea of abandonment and showing abandonment. I've worked with some tenants before or some landlords before about how to demonstrate that, what those procedures essentially are. Sometimes it involves eviction. Sometimes it doesn't. I can't get necessarily quite into the details of yours without kind of knowing all of the pieces of it. But between the ideas of eviction and the ideas of abandonment, there are pathways to get there. Any last questions? Melissa knows that I'm always like, I'm here to answer questions. And you see this hotline phone number. You can call, and believe it or not, you'll talk to somebody. And then if you have a question and you're like, you know, could I ask Aaron about it? They'll like transfer you over to me, and then I'll just talk to you about it. So please extend that all out. Get the word about us from everybody. We are really here to help and to educate landlords as well as tenants. We really want everybody on the same page. Last question: Airbnb, Verbo, etc. fall under these laws and rules? Not by default in any way. However, the thing to know is if you are doing an Airbnb or a VRBO, or you're like a hotel, or renting out your cab or whatever, man, those rules, those definitions, those things that I was talking about in the part of 134.01 and 02, you might find out that if that person doesn't live anywhere else and they're now renting from you, you might be their landlord, even if it's through an Airbnb or VRBO situation. So, a little bit of you want to be a little wary if you're using that.
I have a question.
Yeah.
Yes, after a tenant has filed a formal complaint and landlord has responded to it, how much time should we wait for that response to come back from your office?
That's a really great question. So in our mediation process, after we receive a response from the landlord, what I usually just tell people is like, no news is good news. If we don't need anything else from you, we're probably going to just, we're going to be contacting the tenant again and kind of letting them know, hey, this is the landlord's response. We don't see really anything else happening. And then it kind of ends. If the landlord wants to inquire at any point, say, well, hey, what's the status of this one or the other? We can let you know. The reason why we don't do like a formal case closing in our mediation process is because we never want to completely cut off the idea that communication shouldn't happen anymore. Sometimes the tenant has something else to say, and then we contact the landlord back again. Sometimes the landlord has some additional information. So, we kind of keep things going. So if you, but you might not hear from us again. And if you don't, then there's, that's simply it. There's nothing else to do. But if you are concerned about it, if you do have a complaint, you are concerned about it, you can contact us and we'll probably tell you something like, we're not really anticipating anything more. But, we're never really going to close off that communication to anybody one direction or the other.
Thank you. Good.
Sure.
No news is good news.
Yeah, no news. Yeah, no news is good news is a pretty good way to think of it.
Aaron, great job once again. Thank you so very much, not only to you, but to your partners. It was Andrew and Ben. This has been so informative. Also thank my other co-host who couldn't be here today, Ann Yaus. She has been part of this process, and that's kind of why these all got started. And thank all of you as well for participating in this, and reach out if you have any additional questions.